Good afternoon.
Good afternoon.
Good afternoon.
Welcome to the Fifth District Court of Appeal by Zoom. We have one oral argument this afternoon. That's case number 2024-3011. I'm Harvey J., and I will be presiding today. I have the honor of being on this panel with Judge Eric Eisnagel as well as Judge Joseph Boatwright. It looks like his name was spelled incorrectly on the notice I'm looking at. We'll have to deal with that later. For that, I apologize. Uh, Mr. Korn and Ms. Creed, I know you're both fine and able lawyers, but just a couple of quick things. This is by Zoom. There are vagaries with that I know you both know that we need to be mindful of. If both of you would be kind enough when you're not speaking to turn off your mic, I think that makes for a better presentation. You know this is being recorded. The second thing is the purpose of today, in large part, is to answer questions. So it would be appreciated if you would do your best to answer those questions, because as I know you both know, we wouldn't be here for any other reason, because we would have just dealt with what was in the papers. Anything for the court before we get started?
No, Your Honor.
Mr.
No,
Korn,
Your Honor.
would you like to reserve any time for rebuttal?
Yes, please. I'd like to reserve 5 minutes, Judge.
All right, Mr. Korn, you may proceed.
Thank you, Your Honor. May it please the court. Michael Korn of Korn and Zemer, Jacksonville, for the appellant, Mr. Conchiglia. This case involves a situation which euphemistically described the wife just won too well. The main issue that we address in not only in the papers, but I think will be addressed today, was the trial court's unequal distribution of assets to the wife, which contains several components we'll talk about, I suspect. One is the court's decision to ultimately award the wife 70% of the net proceeds once the marital home sells in 7 or 8 years after her period of exclusive use and possession ends. And then secondly, what we submit is the trial court's erroneous placing of a phantom asset on the husband's side of the equitable distribution chart, that being the first tranche of investment in a $150,000 amount in this Benjamin Tech. Those two particular facts lead to what unfortunately turned out in our position to be an unequal distribution that was both unequal, delayed, and inequitable, and not supported by the facts. Of course, as the court knows.
Let me ask you about that, if I may, Mr. Korn. I think it's well accepted, well recognized that if there is any substantial, competent evidence supporting a finding of fact, that's the end of it for us. Would you agree with that being the standard?
Yes, but the problem, Your Honor, here is the court cannot actually weigh whether substantial competent evidence exists, because the ultimate requirement is that the trial court make sufficient factual findings that would support, in this case, the unequal distribution. And we would submit, and especially as to some of the particular factors, the sub-factors.
And perhaps I missed something in the amended final judgment. I read that just before we got started. It looked like he went through all the statutory factors. What was missing as far as his findings as to all of those statutory factors?
Your Honor is correct that each factor was labeled in the amended judgment. Our position is that the findings that were accompanying each of those factors were insufficient, they were general, they were perfunctory, and they didn't go to the heart of the facts. And let me give Your Honor an example of where I think.
If I may, I'm sorry to interrupt again, but I do have a lot of questions about this, Mr. Korn. You said insufficient. Again, as I understand the case law, if there was any competent substantial evidence, that's the end of it. So insufficient, even if it was insufficient as far as the elucidation of it, wouldn't that be a good enough thing to be something that we've just got to pass our hand over?
Respectfully, Your Honor, I would submit not in this case. And I was going to address one of the particular sub factors which I think the court ought to consider when evaluating whether equity really occurred here. And that was the court's overemphasis, in our view, of the wife's contributions to the marriage. We submitted in our papers, and I would argue to this court today, that although both parties made contributions to the marriage, the husband through his employment and through his very active involvement with the children, and the wife having given up a career and then deciding that she really wanted to ultimately spend more time with the children, evidenced by her midlife career change to teaching, it did not take into account the fact, Judge, that those types of findings could be made in virtually any factual scenario in a divorce case where a wife either chose not to work or chose to leave the workplace. In other words, the decision that the parties made, which is hardly uncommon. This is not a unique circumstance, nor did the court address any of the types of unusual or extraordinary circumstances that are set forth in the case law, which say, if the services that...
Mr. Corn, let me stop you there. Unusual, extraordinary, I think Ms. Creed rightly pointed out. I don't see those words in the text of the statute. Now, the cases may say that. You're exactly right. And I trust you to be candid with the court, but I just don't see either of those terms in the text. And I did read through the statute before we got started. So where is extraordinary in the text of letter A? And maybe I missed it.
Well, the statute, specifically 61075 sub 1 sub A, talks about contributions to the marriage by each spouse, including contributions to the care and education of children and services as homemaker. And we submit, Your Honor, that in this case, the types of services, home care services, household services, were not unusual. They are typical in a situation
Counsel,
where a husband and wife, excuse me, Your Honor?
Counsel, be that as it may or may not be, either way, wasn't one of the factors here the interruption of the wife's career, that didn't the trial court conclude that was by agreement of both parties, that former wife would leave her very lucrative career to sort of raise the children, to allow former husband to advance his career, which is all fine and good, but I'm not saying there's anything wrong with that. I'm just saying, wasn't that a finding? And if so, why is it not appropriate? Why is it an abuse of discretion for the trial court to consider the interruption of wife's career? And then also, my recollection is that there was the trial court did not impute income, or at least not to the same amount, right? So the interruption of wife's career, it's not like she was able to go and get the same career back, right? I mean, maybe it'd be probably would be a very different story if former wife was able to go right back into that very lucrative career. But it seems like on this record, the trial court concluded that really wasn't the case. Why isn't that not competent, substantial evidence on this?
Well, Your Honor is correct, but there's another factor that I think also needs to be considered about the joint decision for the wife to take the household duties over, and that was the point where the very lucrative and one of a kind stock options were cashed out. And so it was not just the fact that the party said, "Hey, I think I'll work and you'll raise the household." They were able to receive substantial funds from that, which benefited the marital partnership. They got the house paid off. They got their children's secondary.
I guess the point is, counsel, at this point, aren't we seems like you're asking us to kind of reweigh this evidence. We're not really that's not our role, right? I mean, I guess what I'm trying to ask you is sort of very directly, the trial court concluded that the parties made a joint decision that interrupted wife's very lucrative, very high-paying career. And I think we can conclude from the trial court's findings that that career was not available to former wife to re-enter. Do you agree with that? Am I wrong about that?
Well, the 2 points, if I might, Judge. One, the vocational expert who testified had said that she could earn in the between $50,000 and $81,000 range. Obviously lower than what she had been earning when she was at Shell. But Judge, this is the point I was trying to get to a moment ago. The idea of her wanting to basically step right back into the corporate world is illusory itself, because she testified at length. She only wants to teach. And she not only wants to teach, she only wants to teach at the children's
Counsel, that
private
may
school.
that may be true, but if she, well, in a hypothetical world where the former position is available and she can go back to making, I think it was she was making over 200,000, right? Initially.
Approximately 200. Yes, sir.
Yeah. In the hypothetical world where that was an option and she just said, hey, I don't want to do it. Right now, that's a different issue. It seems to me like this seems like your argument is a lot stronger at that point, because you have a strong argument for imputation of income and things of that nature. I don't think that's what the trial court concluded here, that their job's available, but she just doesn't want to do it. Am I wrong?
No, well, Your Honor, I think what the trial court concluded was that the wife didn't want to go back into the corporate world. She specifically testified at some length about her desire to be in the children's lives, and in her perception of that was that the best, most effective way to do that was to start as a teacher's aide at Providence School. And then as the litigation progressed, she was able to, at the last day of trial, announce that she was able to get a full-time position, which did throw off some additional benefits. But so this wasn't a situation where she was somehow being now frustrated, leaving the marriage in a frustrated position. She left the marriage from an
Mr. Corn, I thought, though, I read something that your client's vocational evaluator had come up with a set of jobs, and she applied for all those and apparently didn't get any of them. Did I read that rightly?
There was testimony to that effect, Your Honor. That's correct. But to Judge Eisnagel's point, and I think this is the significant one, the imputation that the court did do for alimony purposes, and again, we didn't appeal alimony. That's an abuse of discretion standard that I wouldn't think would be satisfied here. But she was not looking to rejoin the corporate world.
I think you had to counsel. In fairness, let's cut to the chase here. You might have an argument here, but I think you needed to challenge the trial court's ruling concerning former wife's ability to earn, right? Because wasn't the trial court's sort of, when the trial court said, hey, this 70-30 distribution is based in part on the interruption of former wife's career, and it would have necessarily, I think, accounts for the fact that that career is not available. If the career was available and she was just choosing not to go back to it, then it wouldn't really be a career interruption thing. So didn't you need to challenge that ruling of the trial court regarding the interruption of her career?
No, Your Honor, because it was not the issue of, we were not challenging the alimony award. The alimony, of course, the judge gave her the maximum amount of alimony under the revised statute.
No, I'm talking about, did you need to challenge that on appeal and in your motion for rehearing?
Well, what I'm saying is, I don't think it materially impacts the argument regarding equitable distribution. The other thing I would just mention, Judge, is, and we raised it in the papers, there is no basis that I can figure out that tells us why was it a 70-30 split? Why not 65-35? Why not 75-25? The court did not make any sufficient findings that explained why that split was equitable. And before my initial time runs, I do want to address the Benjamin Tech note for a minute, because that also had a contribution to the unequalization process that we had here. The wife argues that somehow this was an appropriate action because the husband took inappropriate action, and we suggest that's not the case. As the record reflects, the parties had enjoyed the benefit of husband's entrepreneurial efforts when those stock options cashed out 10, 12 years earlier. So the fact that he attempted to try to get in with a startup, gave sweat equity to it, which was the representation of the second tranche of that Benjamin Tech stock, shouldn't be deemed to penalize him and basically say, although the judge knows at trial that it's worthless, and contrary to the wife's argument on appeal, there was testimony not only from the husband, but from his sister who worked at that entity, who said it's worthless. The fact that it was held as a note to Bennick, which was his vehicle to make that investment, had nothing to do with the collectability of it. And the judge even said at one point, and it's unclear from the transcript, Judge, as to which tranche he was referring to, but he even says, oh, I thought we were going to take that off the chart. Well, it got on the chart for the full $150,000. This is not a situation where it's a tipsy coachman, because the court could have valued it as of the time of the divorce, because the case law, and specifically referred to the Ward case, which says that if an asset is known to have depreciated or lost value, it shouldn't be attributed to that spouse on the equitable distribution sheet. So for those reasons, those two particular factors, and not even thinking about the award of the marital home, those are the factors that skewed the distribution here in our view. And so to Judge Eisnagel, your point that we were somehow required to do some kind of an alimony change. I don't think it was an alimony challenge. It never was. If the court had not put the $150,000 Benjamin Tech on the balance sheet and a couple of other minor adjustments made, they're virtually at 50-50. And that would have been an entirely appropriate exercise of discretion. Where the trial court respectfully got off the trail was in essence imputing a non-existent asset to the husband and charging him with it. And I know I'm into my rebuttal, 30 seconds more. The findings are contradictory. He first says, I believe the husband. There was no misconduct, there was no dissipation. But then he says, yeah, but this was a bad investment, shouldn't have made. Well, bad investments under the law shouldn't be charged to the party in equitable distribution. I'll reserve the balance of my time. Thank you.
Thank you, Mr. Corn. Ms. Creed?
May it please the court, Rebecca Creed on behalf of the appellee, the wife. We ask this court to affirm the trial court's amended final judgment in its entirety. There has been no abuse of discretion, and the trial court's rulings were supported by competent substantial evidence, as reflected in the final judgment and the specific statutory findings that were made. As to the two main...
Ms. Creed, where Mr. Corn ended, he was talking about Benjamin Tech and that investment. What say you about that? What is your client's retort to that?
The Benjamin Tech investment, it's not a phantom asset. It was $150,000 cash from the parties' joint marital accounts that the husband used to invest in and purchase stock options in this startup company at a time.
Ms. Creed, did it have any value? Was there any value
at the
in
time?
stock options?
The stock options, the husband testified, and I would agree, the sister also said at the time of the trial that Benjamin Tech had no value. But what did have value was the $150,000 from the parties' marital accounts that was used to purchase those stock options. And that was done at a time, as the trial court finds, when the parties' marriage was clearly undergoing a broken period. And during the time when the husband was repeatedly threatening divorce and prior to him filing for divorce. That's at page 1578 of the record. And so at that point in time, that is enough to find that the husband dissipated that $150,000 cash, which is essentially what the trial court ruled by including that amount in the husband's marital column. The trial court's rulings as to dissipation, or the finding, there was no intentional misconduct related to the gambling losses, is what the trial court found. But that didn't preclude the trial court from ruling that this use of cash from the parties' joint marital accounts did constitute dissipation. Again, at a time when the parties' marriage was undergoing a broken period, and also without the wife's consultation and without her agreement, unlike perhaps the facts related to the Black Diamond options. Here, there's a specific finding that the husband made this investment without consulting with the wife and without her agreement. These facts are enough to show that the trial court did not abuse its discretion in allocating this $150,000 amount to the husband's column. The comments made by the trial court about taking this off the table appear to be directed to the other award, the other tranche of Benjamin Tech stock options, which were awarded to the husband for his work consulting with that company. And the wife agreed. She stipulated at trial that as to that asset, those could be held in a constructive trust and valued at $0, but held in a constructive trust for her benefit. But the wife did not agree. And the evidence showed that this $150,000 cash asset, or the cash, was used to purchase stock options that then lost their value, and that this was more than just a bad investment. As to the first issue, the unequal distribution of the marital home, the proceeds, the trial court did go through each of the statutory factors in the final judgment and made specific findings supported by competent substantial evidence to reflect its ruling and to justify an unequal distribution of those proceeds. While the trial court, he made these findings, and there's no requirement that the statute itself, or rather the statute does start with a premise that distribution should be equal, but there is no prohibition against awarding an unequal distribution based on all the relevant factors that's specifically contemplated by the language of the statute. There's no specific requirement in the language of the statute that the contributions of the spouse, of each spouse, have to be some kind of extraordinary or novel circumstances. And here, while certainly judges could disagree as to the impact or the effect of the facts that are presented by this case, here this trial judge did look to each of the statutory factors and made specific findings as to why those factors did justify the unequal distribution of the marital home. The trial court found that the wife had interrupted her lucrative career. Certainly there was testimony that was by agreement, but nonetheless, the wife fulfilled her portion of the agreement and then did even more. She effectively retired, and there has been no showing that she can return to the workforce at the same level and in the same position that she held now well over 10 years ago. The vocational evaluator conceded that she really wasn't trying to get the wife to that same level of earning. And the vocational evaluator had also, in her own analysis, had discarded some of the lower paying jobs that the wife would be qualified for, such as one of the jobs that she ultimately got, which was as the teacher's assistant at the children's school. The wife also, the husband argues that it was just that the wife only wanted to teach and that's all she wanted to do. But there is also evidence, as the trial judge found, that the wife also had accepted a part-time consulting job, essentially, that was on a commission basis, working for a company called Helms Briscoe, that is essentially the same type of work, perhaps, that she had been doing at Shell Motiva, but instead of being the client, she was actually on the side of trying to develop clients and booking hospitality accommodations. The trial court considered the testimony of the vocational evaluator, which included that, again, that she had excluded lower paying jobs from the wage earning range. And the vocational evaluator was not able to provide evidence that the jobs that she listed were open or that the wife would be hired by those jobs. And as the trial judge found on
Counsel,
page 15.
if we could go back to the Benjamin Tech issue.
Sure.
Is it enough? It seems like, correct me if I'm wrong, but it seems like on that specific issue, it seems like that really the entirety of the decision was based upon the fact that the marriage was going through trouble at the time the investment was made. The former wife was not consulted about the investment, and really, I'm not sure anything else. What else? What is it based on? And if that's it, why is that enough? What's the legal argument for why that's enough? In other words, I don't see any finding that the former husband was attempting to, was wasting money in any sense, or that the Benjamin Tech investment was unreasonable at the time it was made. So I guess I just wonder what else is there in the record to support that? And if it is just simply that it was made at a time when the marriage was in trouble and former wife wasn't consulted, why is that enough?
The evidence is not simply that she wasn't consulted, but also that she hadn't agreed to that investment.
Hold on, counsel. Hold on. I think that's probably the same thing. If she wasn't consulted, she probably didn't agree, right? So what else is there besides those two things?
The fact that, as the trial court found, this marriage was clearly undergoing a breakdown at the time, and as a legal
that's the first
standard,
one. The first one is marriage was having trouble. Second one was former wife
Yes.
wasn't consulted. Is there a third?
the husband was at the time threatening divorce and then did follow through on that when he filed for
That
divorce.
sounds like number one. Is there a number three?
No, I'm not sure there's a number 3, but I
Why
think
is that what's the legal argument for why that's enough?
because under the legal standard, as we cite the Romano case, so the husband was using these marital funds for his own benefit. It was his sole proprietorship where he purchased the stock options. So it was for a purpose unrelated to the
Hold on a second.
marriage.
Let's say Benjamin Tech tripled in value. Marital asset, right?
Yes,
Yes
it
or no?
would be a marital
Okay.
asset.
So how is that for his own benefit?
Because what the husband did is he then used, at least there's some evidence that he was then using losses in that Bennick Capital company that he used to purchase the stock, that he used that carryover loss for his own benefit when he filed in
Carryover loss was
2022.
dealt with separately. Didn't the trial court say, hey, you have to redo that stuff?
That
Right?
was those were the stock options that he owned, that Bennick Capital owned, that were given to him as part of his compensation. There were
Okay,
there were
so,
two
all right.
different
But
That's
your
different.
client,
groups.
your client has been given credit. I mean, she was given credit for the carryover losses, correct? The trial court redistributed those.
Well, she has not been yet, and on appeal, the husband has argued that he should not be required to file an amended tax return of the
Well, I understand he's
2022.
arguing that, but that's not what the trial court said. The trial court did allow her to take a portion of those losses, correct?
Assuming that ruling is upheld, that
But
was
counsel,
what the trial court ordered.
was that Benjamin Tech, or was that a different investment? Am I mixing those two things up, or was that Benjamin Tech?
It is, I will say it is unclear exactly what that carryover loss was used for. But at the time that looked like it
But getting back
was,
to Benjamin Tech, where other than the two factors we've identified, I think we've established those are the two factors. Why is it legally? What's the legal argument for giving a worthless asset solely to one party based on those two factors?
the legal argument is that the trial court found and the evidence supports that it is intentional dissipation of that
No, that's a conclusion.
$150,000.
No, counsel, that's a conclusion. Don't give me a conclusion. What's the legal argument to reach that conclusion? Why is it dissipation?
it's dissipation because he took what was the marital cash and used it to buy those stock options. And he did that at a time when the marriage was undergoing
I
a
mean,
reconcilable breakdown.
okay, how is that different than him going and buying groceries? There must be something different, right, about it. What is it? Is it just a hindsight 2020, hey, it didn't work out? Or was there some actual misconduct here that I'm missing?
I'm not sure there was anything in the record that showed that the husband intended to, it wasn't as if he intended to, um,
He didn't intend to lose the money, right? I
I
mean,
don't think he intended to lose the money, no, but that was the practical effect.
no,
And
I
it was,
understand. 2020, hindsight's always 2020, but I mean, was there a finding by the trial court that not sure, if the trial court said, hey, you just intended to lose this money, that would certainly be, I think, misconduct, or at least evidence of misconduct, right? So, but what did the trial court conclude? Even if he didn't intend to lose it, did the trial court make any finding that this investment was so patently bad when he made it that he should never have made it, that it was somehow grossly negligent or something like that?
no, the trial court did not make that finding. I would argue that there were facts that suggested, at least from the wife's viewpoint, that maybe this was at a time when the husband shouldn't have been making that investment. It was July of 2020. He left a very high-paying job to stay home, and then effectively didn't have a job, and that's why he had started this Bennett Capital.
Ms.
I mean,
Creed, Ms. Creed,
yes.
why would this be different than any other investment? I think I'm trying to follow up on Judge Eisnagel's question. Why would this be different than buying any other stock and then the stock, going to zero value? Why would this be any different than that?
I think it would be different based on these facts, given the timing of the investment and also the nature of it, in that it was an investment in a startup company for which the husband was trying to consult to, and that at the time, the parties were undergoing marital difficulties. The husband was threatening divorce. The wife wasn't consulted.
Is it just that every time that anytime there's there's marital difficulty, then all assets have to freeze? No purchases can be made. Is that a matter of law? Nothing can be done at that point.
No, Your Honor, that's not as a matter of law.
Well, how
But
do we
that is
get there? I mean, how do we get there? Without a finding by the trial court that the Benjamin Tech investment was unnecessarily or unreasonably risky or something like that, right? If it's just the timing that it was done and that it didn't work out, man, how does that seems like that would apply to a whole lot of stuff.
I think it's the combination of the factors. It's not just simply that it turned out to be a bad investment. There are at least facts in the record that would suggest that the timing was the choice to make this risky decision in a startup option, invest in a startup, was not good timing, and certainly was, again, without the wife's knowledge and without consulting her. I mean, I
Ms.
don't
Creed,
know, other than,
Judge Eisnagel and Judge Boatwright made good points, but is it a feature, and maybe it's not, but is it a feature that she couldn't access this account? As I read in the record, she was not able to get there and have any impact on this money once it was taken from the marital funds. Is that a feature of this too? I mean, is that a legal basis or not?
I think, yes, it certainly was. She did testify, and the facts show that he basically controlled all of the accounts. And so by his using this to purchase the stock options that were then held in his sole proprietorship, certainly she didn't have the ability to then go look at the records of this proprietorship and these stock options and figure out what was going on. And there is testimony that she didn't know or couldn't figure it out.
Well, so she didn't have access, she didn't have control. If she thought it was headed in the wrong direction, it was just going to head in that direction. She had no ability to be part of that analysis tree. Is that the record here or not?
I think that's the record, not only with this particular investment, but with the other investments. But yes, and again, it is the nature of the investment in a startup in July of 2020, when the husband has left his former job and is now trying to build this consulting
Ms. Creed,
company.
was there any testimony or any evidence presented that these stocks may end up having a value? Because you told me there was testimony that there was no value. Was there any testimony or evidence that they potentially have a value in the future?
There was, the wife testified that she didn't believe that the husband's statements that there was no value, and that she also believed that the husband's I guess the person with whom he formed this entrepreneurial venture, this summit venture, which was a little later after the filing, that she thought that one of the husband's friends with whom he had worked would come in and save the day, and pay for this investment. At some point in time, as of July 2022, there was some evidence that the stock options could have been worth maybe $25,000. That is in the record, and that was based on a letter from the owner, the president of this Benjamin Tech. But I think by the time of trial, you have the husband's testimony that it's worthless, the sister's testimony that she had been working there and was no longer working there, and then the wife's testimony that she didn't believe that it was worthless. So that is the evidence as to the value. Again, I would look to the value of the $150,000 cash, and which did have value at the time, and now that even if there is no value in the Benjamin Tech investment, the trial court could allocate that amount to the husband and his column as intentional dissipation. Again, we would ask this court to affirm as to the amended final judgment of dissolution in its entirety for all the reasons that we argue in our answer brief and today. Thank you.
Thank you, Ms. Creed. Mr. Korn?
Thank you, Your Honor. We have to take the record as it is. And so there is testimony, of course, that the husband said that she was aware of the Benjamin Tech, but we'll put that aside for the moment. I'd also point out that to the extent that the wife claims that she was totally in the dark about everything, husband testified without rebuttal that he would give her a spreadsheet of assets, liabilities, and you'll find that at husband's exhibits 21 and 22. So,
so what's the law on this? Is it a strict liability? Once the I think the trial court described the marriage as in a broken period. At that point, once you're in a broken period, are all expenditures by either spouse at that point sort of a strict liability? If they don't work out, then it's misconduct. What's the law on this?
Your Honor, I would suggest that the law is that that's not the case, that there is no strict liability or no, as you alluded to, a freeze, if you will. I point out two cases. One of them I already mentioned, another one but they're both in the brief. One is the Boutwell v. Adams case. It was a first district case from 2006, which basically held that as a general rule, expenditures and investment decisions which do not rise to the level of misconduct will not support an unequal distribution of marital assets. And in that case, Mr. Boutwell had invested in a venture with his brother. The trial court didn't like that. The first district reversed. The Bush case, which I also referred to earlier, and another case cited in the briefs at 824 Southern 2nd 293. Here the fourth district said it was error to include in the equitable distribution scheme assets or sums that have been diminished or depleted during the dissolution proceedings. And then in directions on remand, the trial court should not include assets depleted by either party in the equitable distribution scheme. So I hope that addresses the legal question, Judge Eisnagel, that you raised. A couple of factual points I did want to address after counsel's argument. There was nothing inappropriate in the husband's departure from Summit, not Summit, the company, that SS&C, which had acquired the original spinoff from Black Diamond. One of the things that was a stressor in the marriage was the husband's travel. And in fact, he complained that this SS&C job, not only did he not like the corporate culture there, but he was traveling all the time. So the leaving there and then literally on the heels of that, COVID-19. So this was not some grand scheme or anything like that. Another important point, counsel referred to Mr. Colley, who was the angel investor in Summit, that he was going to somehow save the day. The trial court totally rejected any attacks on Mr. Colley, accepted his unequivocal testimony. No money was being held. There was no secret plan. So that's a red herring that I think need not be considered. Simply put, it's turned out to be a bad investment. If this was such a scheme, why would he have invested so much of his own sweat equity and time? So yes, as the court has already observed, it was an unfortunate bad investment. I can assure you that if it had tripled in value, as Judge Eisnagel suggested in that hypothetical, the wife would have been there saying, "Great, now where's my share?" I'm reminded of the old fable about who will help me plant the seed. Here, what the husband was trying to do through the seed money from the account that he had argued should have been at least partially awarded to him, but was commingled, and we didn't argue that either on appeal. That between the seed money from that brokerage account and the $150,000 of sweat equity, he was hopeful that this would be a return. It was a good faith effort. And as counsel suggests, there's no showing that it was not made in good faith. He was trying to hit it again. It didn't work out. He shouldn't be penalized for it. And that's unfortunately what happened here in this equitable distribution scheme. So for these reasons, Your Honors, I would suggest that the equitable distribution needs to be remanded, allow the trial court to reconsider it without consideration or calculation of a phantom asset, which we know doesn't exist, has no value, will never have value. The company is defunct. It is gone. And so should this equitable distribution scheme. And I thank the court for your very good questions.
Thank you, Mr. Korn. Thank you, Ms. Creed. That brings to an end our oral argument. Was well presented on both sides. We will be in recess.
Thank you, Your Honor.